So hello, everyone. I'm new to microphones and stages. This isn't my usual environment, so I'll ask for your generosity and compassion while I speak to you all over the next few minutes. I'm very grateful for the opportunity to be able to speak to you all and to contribute to this discussion, which I think is wonderful that it's happening, but also wonderful that it's happening in an interdisciplinary way, recognizing the collaborations that need to happen in order to address these issues that we live through. My name is Pippa. I'm a lawyer and mediator, and I work primarily with nonprofit groups. In my mediation work, I work both with the criminal courts and also with nonprofits and other workplace environments to address issues of sexual assault, sexual harassment, and so it's partly based on that experience that I'm speaking to you all today. I first need to clarify that I'm not here to give any legal advice, and I'm not able to give any legal advice. I'm going to try and provide information and a sort of lay of the legal and quasi-legal occurs, and ultimately different options for recourse, so that whatever decisions anyone makes, hopefully they can be a little more informed. I'm going to discuss three things specifically. The first is what Canadian law says about sexual assault and sexual harassment. The second thing I'm going to address is when sexual assaults or harassment occurs in the workplace, what is your recourse and what are different types of recourse that can be pursued? And then thirdly, what are the pros and cons of non-court-based recourse, specifically alternative dispute resolution, things like mediation, peacekeeping circles, or workplace interventions. So I'll begin first with Canadian law and look at criminal law in very broad strokes. But ultimately, the Supreme Court of Canada has recognized for decades that sexual assault is the same thing as any other kind of assault. It's based on power differentials, it's based on force, and it's based on actions that are taken against another person without their consent. The law is also quite clear that sexual activity or touching is illegal without consent, and consent is a very established principle legally. Over the summer, the federal government proposed a series of changes to the Criminal Code of Canada to make it clearer that sexual assault complainants can't consent to sexual activity while unconscious, or a series of other circumstances in which consent can't be assumed. And changes are also in the criminal code relating to sexual texts or photos or videos can't be used to discredit a claimant when they are alleging a sexual assault. Often when sexual assault cases come before the courts, they can engage in a sort of he said, she said scenario, and the moral character of the complainant can be under assault in that kind of proceeding. So there are changes to the criminal code to try and prevent that from happening. And we've seen recent news stories as well about certain judges or juries who don't understand all of the nuances involved in sexual assaults or sexual harassment cases and who misapply the law. So ultimately, the legal system is a human system, and these structures exist to try and guide and help us navigate them, but it is imperfect. So in very broad strokes again, under the criminal code, any sexual contact without consent is considered a sexual assault. Also understanding that that'll take place along a spectrum. Different types of activities will be treated in different types of ways by the court system. When bringing a criminal proceeding against a person, we've all heard of burdens of proof, and that the criminal burden of proof is beyond a reasonable doubt. And that's a very high evidentiary threshold, Something that came out in the discussions we were having before this formal part of the presentation was how evidence can be such an issue when bringing up these cases. So evidence is something important to consider in criminal proceedings. Also, the remedies and consequences in criminal proceedings will involve prison sentences or can involve some kind of restitution. Then, in addition to criminal proceedings, there are civil proceedings. For civil proceedings, the burden of proof is lower. It's what's called a balance of probabilities rather than beyond a reasonable doubt. So it requires I guess, a lower evidentiary threshold. It's more about, is it more likely than not that a sexual assault happened? And so in that way, it can be an relatively easier evidentiary threshold to make. Also in civil proceedings then, they're usually about compensation and wouldn't involve any prison or criminal sanctions. In addition to then those court proceedings, there are other recourses when sexual harassment occurs in the workplace. So the Ontario Human Rights Code, for example, defines sexual harassment as engaging in vexatious comments or conduct that is known or to be known to be inappropriate. So things like asking for dates, not taking no for an answer, demanding hugs or unwanted touching, rude and insulting language, or commenting on sexual appearance, inappropriate sexual jokes. Those kinds of things have all been recognized by the Ontario Human Rights Code and the Human Rights Tribunal as being prohibited. And if those do happen, then a separate type of recourse is available, which is initiating a human rights complaint. And then there's Canadian Actors' Equity, but that's been spoken about already, so I'll maybe skip that for now. But I do, in about the minute I have left, want to discuss alternative dispute resolution mechanisms. So things like mediation, and it should be noted that in court proceedings, as well as before the Human Rights Tribunal and even equity, often say that if a complaint is brought before going to court or before going to a hearing, more and more people are pursuing things like mediation. So what is mediation? Mediation is a facilitated discussion between parties to a dispute. It's facilitated by a mediator who's a neutral person who isn't a decision maker. And a mediation is really an opportunity for the parties who are affected by a dispute to come at their own resolution. There are a few reasons, or a few pros and cons for pursuing a mediation rather than court proceedings or hearing processes. If I can take one more minute to just briefly discuss the pros and cons, they're important to consider. So one of them is money and time. When a matter proceeds to court or a hearing, it can take a long time. In the case of court proceedings, we're often talking about years. They can be very expensive as well, which is quite unfair for someone who has already experienced a trauma. So mediation can take less time. There are also several resources in the city that offer free mediation services. Mediation can also be more empowering than court processes because they offer more control over the outcome. It's the parties who are directly involved in the dispute mutually agreeing on a resolution rather than trying to convince a judge or a jury of what really happened or how it should be resolved. Mediation can be more creative as well. So while courts are often about either prison sentences or about financial compensation, mediations can include any kind of resolution that is mutually agreeable to the parties. Often, what I've seen in my practice is that they can include apologies, whether private apologies or public apologies as well, which would be much harder to achieve in other processes. And then finally, mediation is more relationship-based. It's not relying on an adversarial court process. It's not interested only in truth-seeking or assessing evidence. It's recognizing that people who are engaged in conflict or who have been part of a sexual assault or harassment experience are still in a relationship of some kind. Not a healthy relationship, but they are still in a relationship. And the process focuses on that. Moving forward, what would that relationship look like, even if it's a relationship of no more contact? There are cons to consider as well. For one thing, it requires a lot of strength and support because the face-to-face aspect of mediation isn't easy. But that would be true of court processes as well. And then the private nature of mediation. So especially in the case of the Weinstein cases, we've been hearing a lot about non-disclosure agreements. Most mediations are confidential, and there are pros and cons to that. Pros being that the private nature of a mediation can be very helpful to both survivors and communities, but also it can be difficult in terms of its implications for perpetrator accountability or bringing light to an issue in an institution. In addition to mediation, there are also opportunities for non-adversarial processes such as peace circles or workplace interventions. And I encourage you to Google them. Both have opportunities to address, they're very similar to mediations, except they don't only involve the survivor, claimant, or perpetrator, but they can involve other people in a workplace who are impacted by those kinds of events and deal with institutional levels of trauma feelings as well as the personal. So apologies for taking up a bit of time, but in breakout discussions, I'm happy to talk about any of this further. Thanks.